All right, this is a good one. If so, I wouldn't do this, but if you're getting called to jury duty, this is one way out. It's called jury nullification. But if you get called to jury duty, this is a great way to exercise your rights. And man, they hate this. The judges, they really hate this stuff. So I'm gonna explain to you why. Here we are at Cornell Law School. Jury nullification refers to a jury's knowing and deliberate rejection of the evidence or refusal to apply the law, either by the jury because the jury wants to send a message about some social issue that is larger than the case itself, or because the result dictated by law is contrary to the jury's sense of justice, morality, and fairness. Essentially, with jury nullification, the jury returns a not guilty verdict, even if jurors believe beyond a reasonable doubt that the defendant broke the law. This can occur because a not guilty verdict cannot be overturned and jurors are protected regardless of their verdicts. There are differing perspectives on the role and basis of jury nullification in American jurisprudence. Some view jury nullification as a right, but there are examples of people being punished for disseminating the information. Interesting. For instance, 2 people passed out pamphlets about jury nullification in Colorado and were later arrested and charged with jury tampering. Indeed, jury nullification is technically a discretionary act and is not legally sanctioned function of the jury. As such, jury nullification is considered to be inconsistent with the jury's duty to return a verdict based solely on the law and the facts of the case. And counsel is not permitted to present the concept of jury nullification to the jury. There you go. There's another big flag right there. Here's the good part. However, there is a historical basis for jury nullification. Its origin is seen where juries in colonial America used jury nullification to protest the British by acquitting defendants. There are other historical examples as well. For instance, in the 1800s, Congress passed a fugitive slave clause, which compelled citizens of all states to assist law enforcement, quote unquote, with the apprehension of suspected runaway slaves. Yeah, tell me, let's hope that shit's not coming back. Some abolitionists used the jury system to protect and refused to convict people under these laws. This was also seen with prohibition laws. Good stuff. Good stuff. Americans speaking up for Americans, right? All right, here we go. States also defer on jury nullification. In California, go figure, Judge Jan Goldsmith requested an opinion about jury nullification related to the case Sparf versus United States, in which the decision was that the California trial jury did not have the right to refuse to apply the law. The Supreme Court case Kleinman versus United States confirms this sentiment. So, whatever. These judges, they're out of hand. Just because it's a Supreme Court case, whatever. Great. That's great. I am positive we can find a half a dozen others that speak against that. But whatever. Interesting stuff. If you are on the list to go to the jury, don't say nothing to these guys about it. You know what I mean? Get in there, listen to the case, and then when you get close to the end of your deliberation, you can go, hey, this is bullshit, and here's why. And, if you craft your words properly, you might be able to make some difference in this world. All right. Peace. Love you. Follow me for more. Hit me up for the Telegram group. It's up in the bio or whatever you call that. It's right up there. Peace. Love you.